Hi everyone, welcome back to the channel. I hope you all are doing great and wish you all a very happy new year. Well, as a New Year's resolution, I have decided to start with a series. And can you guess what series it might be? Well, we will be discussing some of the latest and landmark decisions of Supreme Court as well as High Courts. These cases will be helpful if you are preparing for CLAT, if you are preparing for judiciary, other law exams, or in general for your interest as well. So if you are excited about this series, do make sure to subscribe to the channel to be the first one to get notifications of all the upcoming videos. Also, do mention your New Year's resolutions in the comment section below. I will be happy to read them. So let's start with the very first case of this series. This case is famously known as Proclaimed Offender Case. And the title of this case is Prem Shankar Prasad versus State of Bihar. This case was decided on 21st of October 2021. Well, it's a pretty recent case, isn't it? And that's going to be the very interesting part of this series. We are going to discuss all the recent cases. Now, did you notice the difference? Here I mentioned that this case was decided on 21st of October 2021. But sometimes for many other cases, you get a citation wherein SCC, AIR and then some numbers, some years will be mentioned. Can you tell me what is the difference between these two things? Citations and just mentioning the date when the case was decided? If you know the answer, do mention that in the comment section below. And if you are confused between these two things, do make sure to stick to the very end because I will be clarifying all your doubts. Now, to understand this case, it's very important to know the main parties involved in this case. When a case is filed, there are basically two parties, petitioner and respondent. But then there is no limitation as to how many petitioners and how many respondents can be there in a case. So there can be n number of respondents or n number of petitioners as well in one single case. Now, in this present case, if you see, Prem Shankar Prasad was the petitioner and State of Bihar on the other side is the respondent. But then, if you see this screenshot from Indian Qanun, you will notice there is one S mentioned as in petitioners, respondents. There are more than one petitioner and more than one respondents involved in this case. But then list of this entire petitioners and respondents is not being provided in Indian Qanun. So I had to check the High Court case as well, go to Patna High Court website and I figured out who is respondent number 2 in this case. Why? Because respondent number 2 is very important to understand this case. So there are basically two parties whom we need to remember for understanding this case. First is the petitioner Prem Shankar Prasad and the second party is respondent number 2. Along with State of Bihar, he was also one of the respondents and he is Rajneesh Kumar Srivastava. Now this case was decided by a divisional bench of the Supreme Court consisting of two judges, Honorable Justice M.R. Shah and Honorable Justice A.S. Bopanna. Now whenever parties approach the court, there is always some kind of cause of action. As in there is some sort of dispute between the two parties. And in this present case, it was because of a business transaction. The respondent of this present case, Rajneesh, had to give some amount of money to Prem in terms of some business agreement. Out of this total amount, they agreed that 36 lakhs will be paid in cash and remaining 10 lakhs will be paid by way of check. So based on the agreement, Rajneesh made the payment in cash for 36 lakhs and for remaining 10 lakhs he gave a check to Prem. But when this check was deposited in the bank to demand for the money, this check was dishonored because of insufficiency of fund in the account. Dishonor of check, by the way, is a criminal offence and it is mentioned under section 138 of Negotiable Instruments Act 1881. Usually for check bounce, cases are filed under sections 138 and 142 of NI Act. But along with all these sections of NI Act, mostly when a check bounce case is filed before court, few sections of IPC are also added. Like section 406, criminal breach of trust, 420 cheating, etc. When the check was dishonored, Prem filed an FIR against Rajneesh, and this FIR was filed under multiple sections of the Indian Penal Code, like section 406, which talks about criminal breach of trust. It is a cognizable and non-bailable offence. The maximum punishment for the same may go up to 3 years of imprisonment, or with fine, or with both. Section 407, which talks about criminal breach of trust by carrier or wharfinger, etc. It is a cognizable and non-bailable offence. The maximum punishment for the same may go up to 7 years of imprisonment and fine. Section 468, that talks about forgery for the purpose of cheating. It is a cognizable and non-bailable offence. Section 506, that talks about criminal intimidation. It is a non-cognizable and bailable offence. Punishment for the same may go up to 2 years of imprisonment or fine, or with both. If you notice, few of the sections under which the FIR was filed are non-cognizable offences. As in, police officer cannot arrest without a warrant from the magistrate. In this case as well, the learned Chief Judicial Magistrate of Saran Chapra issued a warrant of arrest. This warrant was issued on 19th December 2018. And since the time this arrest warrant was issued, respondent number 2, that is, Rajneesh, was absconding. He was concealing himself from the arrest. And because Rajneesh could not be arrested, he was absconding, learned Chief Judicial Magistrate had to issue proclamation. Proclamations are issued under section 82 of Code of Criminal Procedure. What are proclamations basically? Proclamations are issued in order to formally inform the person that against whom there is an arrest warrant, and he should better present himself before the court or before the police station. These might be published in the newspapers, like locally circulated newspapers, or these may even be served at the residential address of the accused, or even in some police stations or other publicly accessible places. These may be pasted. In this case as well, proclamation was issued against Rajneesh. When proclamation was issued, ideally Rajneesh should have presented himself at the designated place and time mentioned. But what he rather did is he applied for an anticipatory bail. So anticipatory bails are basically applied when we have the apprehension that we may be arrested under some sections of some legislation. Maybe we feel like an FIR is being lodged against us and we may be arrested anytime. In order to avoid that future probability of arrest, we are applying a bail application right now itself. Ideally, anticipatory bail applications are filed at the stage when FIR is lodged or it's about to be lodged. But in this case, when Rajneesh applied for the anticipatory bail, already proclamation was issued under section 82 of CRPC. When this application for anticipatory bail was filed before the trial court dismissed the application. Trial court said that this person is absconding for all this while. Even after issuance of proclamation, this person was absconding and he rather applied for anticipatory bail. So there is no valid ground or reasons for issuing anticipatory bail to this person. Thereafter, the accused approached the High Court of Patna for an anticipatory bail application. And ignoring what all happened previously, High Court of Patna did allow the anticipatory bail. High Court of Patna said if this person is arrested or surrenders within 6 weeks from the date of this order, he shall be released on a bail bond of 10,000 rupees with 2 more sureties of the same amount. Prem was really aggrieved by this decision of Patna High Court and he approached the Supreme Court of India by way of a criminal appeal. And that's what we are discussing today in this case, Prem Shankar Prasad versus State of Bihar and others. The High Court of Patna was of the opinion that this entire conflict that has taken place, it was just because of a business transaction. And in every single case where it's a matter of check bounce, it cannot straight away attract provisions of section 406 or 420 of IPC. At max, it should be attracting provisions of the Negotiable Instruments Act like sections 138 and 142. But in this present case, even after the investigation, when charge sheet was filed and Rajneesh was charged under section 406 and 420 of IPC as well. When Prem approached the Supreme Court by way of a criminal appeal, Supreme Court quashed this order passed by Patna High Court. Because by this time Rajneesh was already released because of his anticipatory bail application, Supreme Court also ordered him to surrender himself within 2 weeks from pronouncement of this judgment. And once Rajneesh will surrender himself before the trial court within that mentioned 2 weeks duration, it will be open for him. He can apply for a regular bail. So the provisions for regular bail will be open, but then he is not entitled to apply for anticipatory bail. And based on the merits of the case, court can take a decision whether to release Rajneesh on a regular bail application or not. And that's how Supreme Court decided this matter. That's why we call it as proclaimed offender case, because proclamation was already issued by the time he applied for anticipatory bail. Well, wait, at the starting of the video I asked some question, right? Let me answer that. The question was, why for some cases we see a proper citation with year plus some reporter's name mentioned like SCC, AIR and stuff, plus some numbers. And for many other decisions, we only get the date when decision was pronounced. It's because for the cases where you get a proper citation, those are already published in some reporters. And the ones where you don't find that, these might be pretty recent cases. And these are yet to be published in some or the other reporter. And this citation is very helpful for us if we want to refer that case from some reporter. But what are reporters? Usually when you visit a law library, you will see a separate section dedicated for these reporters where they are arranged based on years. So if you are looking for some case like A.K. Gopalan case, you would know exactly which years, which volume, which reporter you need to pick, and there also in which page number you would get the case. It's just a way to make our life easier. And with that, I will end this first video of this series. Do let me know if you found this series helpful. Plus, if you have any more video suggestions, you can leave that in the comment section below. If you found this video helpful, do make sure to share it with all your friends and also with someone who might be randomly interested to know what's happening in the legal field. And I will see you next time with another one. Until then, bye-bye.